Rewritten. Welcome back, because today's video is a masterclass in how sovereign citizen tactics collapse the moment they collide with a real courtroom. What starts as a routine appearance spirals fast when a self-described Moorish American refuses to acknowledge the very name on the court docket. He believes wordplay and semantics can override the law. Instead, every argument digs the hole deeper. With active warrants already hanging over his head, none of these choices solve anything, they compound the consequences. And here's the twist, this video covers two separate court appearances, both packed with moments that expose just how quickly these legal games fall apart when reality takes control. Buckle up, this escalates fast.
How you doing?
I'm good, thank you. What's your name, sir?
If I can help you.
I'm Williams L.
Yes, Your Honor, but the defendant is identified in the docket as Michael Williams. Is that correct, sir?
Yes, that's the name they're calling me, but I am
Okay.
Williams L.
I understand.
Michael Williams. Okay.
No,
Mr.
I'm not
Williams, I'm
Michael
asking-
Williams, Your Honor.
Okay.
I am Williams
Okay.
L.
Rewritten? And this is exactly where the strategy collapses almost instantly. Mr. L isn't the attorney of record for Michael Williams, which means he has absolutely no legal authority to speak or act on his behalf. End of discussion. This is the classic sovereign citizen sleight of hand, attempting to separate themselves from the name on the docket, as if rejecting a legal identity somehow erases responsibility. In their world, words are armor and semantics are loopholes. In the real world, courts have heard this routine thousands of times, recognize it immediately, and shut it down without hesitation. Instead of creating distance from the case, this tactic only highlights the disconnect from reality and burns through the judge's patience fast.
So here's the thing, Williams L. I have to call you what's on the documents that I have present for me in court today. We can either handle it that way, or you don't have to handle it, and then it just will be like you didn't show up to court today.
No,
So it's
Your
either
Honor,
way,
I'm just
but I
letting
have
you
to
know
call
who I. Your Honor, I'm just letting you know who I am.
Okay.
I am Williams
That's fine.
L. I am not Michael Williams. They kept calling me Michael Williams. I told them who I was. I am a sovereign Moorish American. I'm not United States citizen, Negro, Black, or color, Your Honor.
Okay, so let me tell you, Mr. Williams, this is the last time I'm gonna say it, and this is all I have for you. If you don't wanna handle it under that name today, then I have to act as if you aren't present. And so that's fine, but I
You
have
say
to
what?
call
Hold
you
on.
what's that document, okay?
Can you repeat that? Can you repeat that,
I
Your Honor?
said, if we can't handle those matters and those tickets that's on that case under that name, then that's fine, but it's gonna be as if you didn't appear for court today, because I have.
Ma'am, I'm here today, ma'am.
Right, so I'm just saying, when I.
Williams
call those
L is here
documents-
today. I'm
Did
just
you-
letting you know.
This is the moment the court draws a hard line and snaps everything back to reality. The linguistic games aren't the issue. The case is against Michael Williams, the name on the record. No matter how hard he tries to invent a separation, the judge cuts straight through the nonsense and refocuses the courtroom on the only questions that matter: is the defendant physically present? And is he prepared to participate in his own trial? With T.
I am Williams L.
So that's fine. When I call it on the record, I'm gonna have to call it on the record as the name on the ticket, just so you know, okay?
Okay, and I'm gonna let you know that I'm Williams L. Okay, I'm cool
That's
with
fine.
that, and I'm letting you know who I am. I'm a
Okay.
Moorish American.
Okay. Did you
Sovereign.
wanna offer? Okay, did you wanna offer for it or no? Are you gonna try and I need to kind of know where you're going. Are you gonna want a trial? Are you gonna try and wanna
No, I
offer
do not
with-
agree. I do not agree to none of this. I'm sovereign.
Okay, so if you're not gonna participate, we're just gonna act like you're not here today, and I'm going to go ahead and.
I am here today, ma'am. You seeing me right here? That's on
You
record.
have to- Listen, just because you show up doesn't mean that you're here. You have to participate, okay?
Ma'am, I'm a sovereign. I'm letting you know who I am.
Listen,
I'm
and
participating. I do not
that's
agree.
Mr. Williams, that's fine, but if you don't participate, saying you're a sovereign.
Doubling down on the sovereign label only makes things worse. It doesn't strengthen his position or add a shred of legal credibility. All it does is spotlight how far removed the argument is from reality. What might sound clever in online forums lands in court as recycled, long-debunked talking points judges have heard endlessly. At this stage, it stops resembling a defense and becomes background noise, because none of it alters jurisdiction, identity, or the court's authority to proceed. The label doesn't protect him. It signals that the case is about to move forward without his cooperation.
I'm just letting you know who I am. That's violating a constitutional right, man.
So do you want an offer or not? That's my question.
Do I want a what?
An offer to the tickets or not?
Do I want to? I can't understand. You said, do I want to offer?
Do you want an offer? Do you want to try and resolve this today as far as?
Yes, I do want to resolve it. I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
Oh, no, that's not going to happen. So you can, I'm not going to.
I'm speaking for myself. I have no attorney, so I'm speaking for myself. I asked for this case to be dismissed. You're violating my constitutional right.
How do you have constitutional rights if you're not a citizen?
I'm not a United States citizen.
So how?
It's refreshing to see the court finally cut through the noise and drag the discussion back into the real world. Yes, fundamental human rights apply to everyone, citizen or not, including access to the courts and due process. But that's where the misunderstanding ends. The legal system doesn't operate on personal belief systems, political slogans, or a rejection of civic structure. Beyond those baseline protections, rights and privileges are defined by law, not ideology. Courts don't run on patriotism tests or semantic gymnastics. They run on jurisdiction, statutes, and accountability, and no amount of rhetorical posturing can blur that line.
You got to uphold to the sovereign, sir. You can't. I'm not United States citizen. I'm not Negro, black, or color. You're not under I'm not under your jurisdiction.
I understand, but my question to you is, if you want to rely on your constitutional rights, how do you have constitutional rights if you're denying your citizenship?
Yeah, because I'm an American. I'm a national.
I get
I'm
it,
a
but
Moorish American. I'm not United States citizen corporate. I'm a Moorish American. I'm an American national.
Okay, but you're still present in this jurisdiction, right?
I just asked for this case to be dismissed off lack of jurisdiction.
Written. And the judge makes it unmistakably clear, the answer is no. If you truly intend to represent yourself and challenge jurisdiction, there's one non-negotiable requirement: you must actually participate in your own trial. Courts don't argue with ghosts, entertain commentary from the sidelines, or reward silence with special treatment. You don't get to opt out of the process while demanding control over it. This is the moment to stand up, engage, and play by the same rules that govern everyone else.
This is the date and time set for an arraignment on a bench warrant. Do you want to participate in these proceedings?
Yes, I'm here on special appearance. I'm just letting you know who I am.
All right, so how would you like to move forward with this matter, sir?
I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
All right, that motion has been denied. How would you like to move forward on these matters?
I just told you what I would like it, so I don't know. I'm just here on special
appearance. It's been denied, so you can either participate today.
Simply being present isn't enough. Participation is the absolute baseline. And this moment perfectly exposes why self-representation is such a high-risk move. A competent attorney would already know how to respond, when to object, and how to preserve issues for the record. Instead, we're watching uncertainty unfold in real time. The court isn't there to coach anyone through basic procedure. Sarcasm aside, the outcome is almost inevitable when someone walks in unprepared, overconfident, and convinced they can improvise their way through a legal system that doesn't bend for guesswork.
I have no attorney, so I'm just letting you know. It's been denied, so we can keep going on with proceedings. I am Williams L. I'm not a United States citizen. I'm not Negro, black, or color. I'm not Christian.
All right, Mr. Williams L. It appears to the court as I'm making a record that he does not want to participate in these proceedings.
I told you I wanted to participate. I'm just letting you know who I am. I told you for the record.
All right, he would like to not participate in these proceedings. He has told me that he is the person known as Williams L. and not the person on these tickets, so he is not appearing on behalf of this person. This person has not made themselves available to the court today as an arraignment on the bench warrant, so these matters will stay in warrant status. Thank you.
Well, that's certainly a choice. And the court isn't about to beg for cooperation. If you choose not to participate, the process doesn't pause or negotiate, it simply moves forward without you. And those warrants? They stay exactly where they are. Silence isn't a strategy, and it never has been. To his credit, he did return the very next day to face the judge directly. But any hope for a turnaround fades quickly. The same recycled arguments, the same defiant posture, and the same predictable result, just stretched out over more time on the road to an outcome everyone could see coming. Wait, did he really just claim he isn't subject to any statutes? That's the moment patience evaporates. Fine. Let him represent himself, because what follows is about to turn into a courtroom lesson everyone can learn from. When someone confidently insists that state laws don't apply to them, they're practically inviting the judge to explain, line by line, exactly why they do. If he wants to transform his trial into a live seminar on jurisdiction and Michigan statutes, the court is more than prepared to let reality do the teaching, clearly, thoroughly, and on the record.
So what option would you like today? Of those that I gave you, sir. You can have.
Ma'am, I'm a sovereign. I do not consent. I can't. I can't
So here's
consent.
what's gonna happen. So I want to make sure you have all the options. You can't consent to anything. So that means that you don't want to participate in the process. So it's just gonna go back into warrant status because you have to pick one of the options. Yes.
Ma'am, I'm a sovereign.
And you can you were in the city of Detroit on a street in a vehicle. And I understand what you just said. That's why I said,
right.
did you want counsel?
I'm not a United States citizen.
Okay. All right.
Nobody have improved jurisdiction. I'm a Moor. Nobody have improved jurisdiction. I'm under common law. Statutes don't apply to me. I'm under common law.
That's okay.
Supreme Court case.
That's
Supreme Court case, Self versus Rader. Statutes don't apply to me. I'm on common law. And if there was a crime committed, can you please show me the injured party? Or I ask for this case to be dismissed off lack of jurisdiction.
I deny the motion for the case to be dismissed. So you have these options, or else it's just going to remain.
And I'm under duress because you forcing me saying you're going to put a warrant out for my arrest.
It's already out there.
But that's violating my 13th Amendment. You can't enslave me unless a crime has been committed.
So you can't
violate my
constitutional
rights.
Let me finish talking. You can't claim you're sovereign and then claim rights under the Constitution. That's not how it works. No, that is not how it works.
Ma'am, I'm not a United States citizen. I have a nationality.
Okay, so that means that
you have to go by
either the laws all apply or none of them apply.
The laws do apply. What, do you have a liability? Do you have a bond? Did you swear an oath to the Constitution? I would like to see that.
Yes, I was going to say I did do that, but I don't have to show you any of that because I wasn't the arresting party. I'm just here to make sure.
Do you have a liability? Do you have a bond?
Listen, I'm not going to argue with you.
I'm not arguing. I'm under law.
Mr. Williams L. Those are your options. If you don't want any of those options, it's going to remain in warrant status.
You're forcing me. You can't do that.
Okay.
You can't do that, man.
Right.
You can't go against Constitution.
Okay, Mr.
You took an oath.
Williams L.
You swore an oath to follow the Constitution.
I did.
That's why I need your liability bond. Do you have a liability bond?
No.
You don't have a liability bond?
No.
Wow.
Let's be clear, none of this happened by accident. This situation is entirely self-inflicted. Refusing to participate didn't protect him from consequences. It buried him deeper in them. This could have been painfully simple: acknowledge your name, allow the public defender to do his job, and there's a strong chance this would already be over. Instead of being at home with no warrants hanging over him, he's back in the courtroom watching them get extended in real time. This isn't the system failing him. It's a textbook example of choosing theatrics over cooperation and paying the price.
I was about to say, if you don't want any of those options, then your only other option is that I have to leave it in warrant status.
I do not consent. I'm here. What warrant? That I didn't show up?
That you didn't want to choose one of these things.
I don't have to. You can't force me to do that, all right?
You're right.
You can't force me. You can't put a warrant out. I would like to talk to somebody, a chief judge. You're violating my constitutional rights.
You can go to the fifth floor and make a complaint.
That's because you're violating my constitutional rights.
Okay. All right.
And I'm going to ask the sheriff for your liability bond.
Okay.
Hey, I don't want to do that.
Okay. You can ask him. Go ahead and ask the sheriff for my liability bond. It's fine.
Took an oath to swear to the Constitution. You took an oath. I'm under common law. I'm not under statutes or regulations.